Welcome everyone to our webinar today on preventing employee competitors, how to protect your business. My name is Saeidul Haque and I'm a senior associate in LegalVision's employment and health and safety team. So just before we begin today, just a quick couple of housekeeping items. So we will be recording this session today and you will be emailed a copy of it. So if you do miss anything, you will have a chance to look back at this later on. I'll also be looking to take any questions that you have at the end, so please feel free to submit these in the Q&A box, and I will try and get through as many of these as I can at the end. Finally, there is also a survey at the end of this webinar. I would be grateful if you can complete this just to give us any feedback for future webinars. So for the next 48 hours, you are also eligible for a free consultation with LegalVision to discuss how we can help your business. So all you need to do is really provide your contact details in the survey at the end of this webinar, and you can claim your complimentary legal consultation. So in terms of the contents today, I will be discussing what you can do to protect your business from employee competitors. So I will cover what you can look to include in your employment contracts, practical tips on protection of confidential information and intellectual property, workplace and IT surveillance, created information barriers and limiting access to sensitive and valuable information, what to do when an employee resigns, and enforcing restraints as well. So at the end of the webinar, as I say, I will be answering some of your questions. So please submit them through the chat function in this webinar, and I'll look to get through as many as I can at the end of the webinar. If I don't get to your question, please just feel free to leave your contact details in the survey at the end of the webinar, and you can claim your complimentary legal consultation and book a call with me, and we can answer any questions that you may have. So moving on to the first topic today then. So obligations on your employees and the source of these. Well, obligations really can be derived from two main elements. The first of which is the express terms of the contract of employment, which is usually the express agreement between the employee and your company as the employer. And this can include things like an express confidentiality clause or even post-employment obligations. In addition, some terms may be set out in what is known as a collective agreement, which will usually be incorporated and referred to in the employment contract. But what does this mean? Well, really, all it means is that as an employer, you may have an agreement with employee representatives, which can be trade unions or staff associations, that allows you to negotiate with them in terms of terms and conditions of employment, such as on pay or working hours as well. The agreement will also usually state that employees are covered by such an agreement, and the terms and conditions the agreement will cover as well will typically just be briefly covered in the employment contract itself. Moving on then to implied terms. So this is the second element to consider, and these are rights and obligations which are not expressly stated as a contractual term, but may be implied into the contract or relationship, either by common law or statute, or by your custom and practice as a business. When your contract is silent or unclear on an issue, the courts and tribunal will often consider whether such a fact is in fact implied, or whether in fact a term is implied rather, to reflect what you or the employee attended at the time the contract was actually entered into. They usually decide this by looking at a number of factors, including the conduct of the parties at the time, and other considerations include the business efficacy or effectiveness test, and also the officious and overbearing bystander test as well. Specific examples of this, and some of this will have been developed by case law, includes an implied duty on your employees to serve your company with good faith and fidelity, which essentially means loyalty and reliability. There may also be a duty of confidentiality, a duty not to misuse your property, a duty not to compete during the relationship, and also a duty to not act in a position of conflict of interest, which is a big one. In some cases, employees may owe fiduciary duties to their employers, especially in positions of trust or senior management roles, such as directors. So fiduciary duties are essentially set out in the Companies Act 2006, and they require the employee to act in good faith and promote the success of the company, avoiding any conflicts of interest and not profiting personally at the expense of yourself as the employer or the company. The best way for an employer to enforce obligations is through a carefully drafted term in the contracts of employment, which I will be outlining when drafting an employment contract now. So when it comes to key things to consider included in an employment contract, you may want to consider carefully drafted restraint clauses, and these are commonly referred to as restrictive covenants, post-termination obligations, or simply just restraint clauses. And there are two main types of restraint clauses. We have non-solicitation clauses, and we also have non-compete clauses as well. And what these clauses can do is they can prohibit employees from soliciting your customers or clients, your employees. It can stop them from working for a competitor, setting up or competing business as well. So that is quite a big one as well, which we'll come on to more later on. You may be wondering, well, why do we need restraint clauses? Well, as a business, you invest a lot of time and money into your staff, and that could also be time and money invested in developing proprietary information that gives you maybe a competitive advantage or a commercial advantage over your competitors. It can give you, it may be a case that you invest a lot of time and money into building a specific client base, which may have been over a very long period of time. It may be that you establish a network of key suppliers and stakeholders. Again, a lot of time investment in there. And also, just in fact, the recruitment, training, and retention of high performing employees as well. You invest a lot of time and money into your employees. So it's only right that you get to benefit from that as well. Your business could really suffer greatly if one of your employees decided to leave and then establish essentially a business that is identical to yours. They actively pursue perhaps your most valuable customers or even try to recruit your highest performing employees. Without restricted covenants, you cannot stop that employee from engaging in competitive conduct because essentially it is a free market. Now, what should you include in restraint clauses? Well, the devil is really in the details, and restraint clauses must be carefully drafted. When challenged in court, a restraint clause is generally unenforceable unless yourself as the employer or the company can prove that the clause is reasonable and does no more than to protect the legitimate interest of yourself as the employer. Some of the key principles applied by the courts when deciding whether or not a clause is enforceable would be firstly to look at whether or not you protect a legitimate interest. So to be enforceable, you must ensure that the clause is drafted carefully to protect a legitimate proprietary interest for which the restriction you are putting in place is necessary. It is reasonable to try and protect things like your trade connections, your client contacts, and even your confidential information as well. The second thing to look at is whether the sole purpose of the restraint and whether or not it is just there to prevent competition or whether it's there for another purpose. If the purpose is solely to prevent competition, it wouldn't be enforceable in those circumstances. The third thing to look at is reasonableness. So the restraints must be reasonable for them to be enforceable. So all you need to do is ensure that it adequately protects your business, nothing more. It also should not be damaging to the public, and it should be reasonable in the public interest as well. When decide whether or not the restraint clause is reasonable, the court will usually look at what would have been reasonable at the time you entered into the employment contract itself. I'll give you some examples of unenforceable clauses. So if you restrain an employee from approaching all of your customers, it's unreasonable to expect them to really know who all of your customers are, including past and present. But if the clause simply prevents an employee from approaching one of the customers perhaps that they've been working with or customers in general that they've been dealing with perhaps in the 6 to 12 months before the termination of their employment, then that clause is more likely to be enforceable. Another example would be restraining an employee from working for a business in the same industry for 3 years from the date of termination. This would often be considered too long, and it's also unreasonable to expect an employee to leave the industry and find a job elsewhere. What is considered reasonable duration of the restraint period really depends on the seniority of the employee concerned, how intimate they were with key customers, and also their salary. Currently, 6 to 12 months is considered reasonable for most mid to senior level employees. But that being said, there has been scrutiny of restrictive practices between employers and employees more recently. In fact, in May last year, the Conservative government confirmed that it would be introducing a statutory cap on non-compete clauses in employment contracts and worker contract. And that cap, they said, would be 3 months. This hasn't been introduced as of yet, and there is currently no indication on when this will come into force, and also whether or not it will impact existing agreements or any new agreements as well. So watch this space. It will be interesting as well to see whether or not the new Labour government actually decides to move forward with this or not. So really, it is important to tailor the clause to each employee and the facts and circumstances as they present themselves. Courts will not ordinarily fix or seek to amend unreasonable restraint clauses, especially given the unequal bargaining position between an employee and their employer. If any part of the clause is considered unreasonable, they will likely strike out all the unreasonable parts of the clause, in which case you are likely to be left with no protection or little to none. Separate to restraint clauses, you should also consider including clauses that protect your confidential information and intellectual property. So employees who become competitors, usually what they will do is steal customer lists, documents, and information that will make it easier for them to service those particular customers. So in the case of a software company, for instance, the employee may steal things like source codes or ideas, whereas in the case of consumer good companies, an employee may try to steal product ideas, information on new product launches, and even the marketing strategy itself. So if your business relies heavily on trade secrets to derive income, you should consider a more detailed definition of confidential information in your contracts, or even a separate confidentiality agreement, which is often referred to as an NDA or a non-disclosure agreement. When it comes to intellectual property in the UK, the starting point is that an employer is the first owner of most IP rights relating to materials and invention created by their employees during the course of the employee's regular duties. That being said, to ensure that there is no misunderstanding or issues when proving ownership of IP rights, it's also important that you have a clause clearly stating that any IP developed by your employees during the employment relationship belongs to the company. This is particularly important in contracts with employees who are likely to create significant IP in the course of their duties with yourself. The starting point really then is to identify the information that can be protected, because when you try to enforce restraint clauses, you have to prove to the court that there is a legitimate business interest that needs protection. And often that interest will be confidential information, such as a trade secret, which is essentially valuable information that gives your business a competitive advantage. Identifying that information and ensuring that your employment contracts on confidentiality clauses as well protect that information is really key to preventing or stopping competitive behavior of your employees. Finally, it's also important that the person drafting your document understands the difference between the information that is capable of being protected and what is not, having regard particularly to the business that you operate. If you do have any questions, as I mentioned at the outset, please take advantage of this complimentary legal consultation offered at the end of this webinar. I'll be more than happy to address any questions that you have. Another way to ensure that your sensitive information is protected is to implement information barriers and also limit access. So most restraint clauses involve employees downloading and extracting confidential information to their personal device, or for them sending that information onto their email addresses, personal email addresses, of course. This usually happens before the employee leaves the business, and by the time the employer finds out, it's often too late. So what we'd recommend is that you conduct regular IT surveillance and random email audits to ensure that your employees are not misusing confidential information. And if you don't already have workplace surveillance and an IT monitoring policy in place, you should work with a lawyer to develop and implement such a policy. This is because there are legal considerations you need to bear in mind before you start monitoring your employees' emails, including, of course, the UK GDPR, which is the General Data Protection Regulation. You should also potentially consider working with an IT provider to ensure that your system keeps a detailed log of your employees' IT activity, and that log is kept in line with your data retention policy, again, having regard to the GDPR. Having a detailed IT activity log ensures that during an IT audit, you can quickly pick up on any unauthorized activity. And also, in the event you do discover that a former employee has engaged in competitive behavior and you find that they have taken customer data and perhaps confidential information, and you want to take legal action, you essentially have a body of evidence that will be sufficient to support your case. Information barriers is something else that you should also consider because you should set limits on what your employees can and cannot access on your internal IT systems. So what you can do is essentially consider having multiple access levels and privileges and setting up information barriers between different teams or sections of the business or even depending on their seniority. So example, an administrator may only have access to level 1, whereas director may have access perhaps to level 5 if that is the highest level, of course, in the business. So employees should really be only allowed to have access to what information they need access to. So they shouldn't have unrestricted access to information. Otherwise, that also potentially poses a risk of a data breach, which again, we have to bear in mind when it comes to the UK GDPR. So for some information, such as valuable templates or precedent, you could allow employees to view the information, but not download it. And what this would do is allow employees to use the templates to do their job, but they can't download it to their devices to use it to set up a competing business perhaps in the future. You should also really ask yourself, do they really need it to do the job? And if the answer is no, then don't give them access because you might have a situation where perhaps, I don't know, the business owner might say, well, our culture is all about transparency, but that could really come back to bite you later on down the track when you might find, for instance, that a former senior employee that you spent years training decides to leave the business, set up a competing business and hits the ground running in less than 2 weeks. And you might see, during those 2 weeks that you lose perhaps 5 of your most valuable customers. And you then realize perhaps, when it's too late, that actually that employee has taken all of your materials that you spent years developing, and that's how they manage to service those clients immediately. Or too often I've seen a situation where an employee does this and they often say to those clients, I can just provide the same service that you receive at the moment, but I'll do it for half the price. So effectively undercutting you and taking the business away from you as well. So as I say, what I'd recommend you do is work with an IT provider, or if you have an in-house tech team, work with them as well to set up information barriers and also multiple access levels and privileges. Now, when an employee resigns, some employers insist on those employees working out their notice period to make sure that there is a smooth handover. But it's often during that notice period that employees start engaging in competitive behavior, because that's often when they start to get disgruntled and they might consider things like stealing information and also trying to poach your customers as well, or making perhaps a list of those valuable clients that you have. What we'd recommend that you do is consider placing high risk or key employees on garden leave, ensuring, of course, that the employment contract has a provision for that. And garden leave effectively suspends an employee from duty while they remain employed on their full salary. And what that means is that they're required to stay away from the workplace, but they can't work for anyone else for that notice period that they spend on the garden leave. So small business owners typically ask high-risk employees to work out their notice period, and this is common with those businesses that rely on one person to do most of the work. But what I would say in my experience is that savvy employers ensure that they work in a team, and that helps to minimize the key person risk, so that if one person does leave the business, your business isn't severely disrupted by just that person. So before you start placing employees on garden leave, you should think about how you can change the way you work, ensuring that the work is evenly distributed and information and knowledge is, of course, shared across the business rather than being limited to one individual. So what should you do during garden leave? Well, what you should do is immediately collect all of the employees' work devices and suspend IT access to minimize the risk of them taking any of your key data and confidential information. You should also consider a IT audit to ensure that the employee has not misused any confidential information. And this is so that if you do find that they have misused that information, that you can act on it quickly as well. You should also consider contacting key clients that are perhaps close to an employee because they may have developed a relationship, particularly if an employee has been with the business for a long period of time. And what you should look at doing is focus on winning them over and preventing them from really leaving your business if and when the employee leaves, of course. You should also look at focusing on retaining high-performing staff members and spend time talking to them to prevent them from essentially being poached by an ex-employee. The common scenarios where you might need to take steps to enforce post-termination obligations are as follows. It may be that your former employee is disclosing or using for their own benefit, or perhaps even the benefit of their new employer, your confidential information or your intellectual property. You may also have a situation where your former employee has commenced work for a direct competitor or started a new business in direct competition with your own, which is commonly the case. You may also need to consider action if your former employee is poaching your clients, customers, or perhaps even other employees. But you may be wondering, well, what do you do when you face one of these scenarios? So what we need to look at is how do we enforce restraints of trade clauses or restraint clauses in employment contracts? Well, firstly, what you want to consider is issuing a letter of demand, which spells out really the obligations under the employment contracts and also highlights the employee's conduct. For example, breach of a restraint of trade clause, such as solicitation of customers, maybe they're trying to poach your employees, so on and so forth, or even misuse of confidential information that belongs to you as the employer. And what the letter of demand will seek to do is it will require the former employee to provide a substantive response to the allegations. So it may be that you've seen the employee trying to poach employees, and perhaps one of the employees notified you of that. You may want to refer to that in the letter of demand. You may also want to ask them to hand over any and all confidential information or delete it, and also to sign an undertaking, which is effectively a set of promises confirming perhaps that copies of any confidential information they have been destroyed, that they will comply with their contractual obligations under the employment contract, and that they will cease all competitive behavior. You can also consider a letter and undertaking to a new employer. So what you would essentially do in that circumstance is issue a letter to the new employer and alert them to the employee's obligations under the employment contract and request for the new employer to provide an undertaking that they will not induce that former employee of yours to breach the obligation that they owe to you under the terms of their employment contract. Now, if that doesn't work, and if the employee fails to comply with the demand in the letter, you or the company will need to decide whether or not to commence legal action through the civil courts. Ordinarily, this will start with seeking an injunction, which is effectively an order to stop the employee or perhaps even the new employer from continuing to engage in competitive behavior. But one key element to consider is that you must act quickly because time is of the essence. And it's one of the very first elements that a court decides to look at when deciding whether or not to grant an injunction, because they need to consider whether or not, without an injunction, you will suffer irreparable harm that cannot be compensated by financial sums. So the longer you leave it, essentially, the more difficult it will be to convince a court that the injunction is necessary because most probably the harm will already been done. Costs are another section that you need to consider because restraint cases are not cheap. And this depends on how complex your IP or confidential information is and how far you are willing to progress this matter as well. It is important to engage lawyers that really understand your business because your lawyer really needs to be able to convince the judge that your business is under threat by this ex-employee or the new employer, depending on the situation, and that it requires urgent protection by the court. To successfully convince a judge, your lawyer must understand how your business works. And by engaging a lawyer that already understands your business, you can save days of work explaining your business to your lawyer, and you can move on to actually taking action because, as I say, time is of the essence. But you should also consider alternatives to litigation, and this may include ADR, which is alternative dispute resolution, and options of ADR include arbitration or mediation to minimize the cost and time expenditure associated with litigation. It may well be in the party's best interest to settle the matter rather out of court, particularly having regard to matters such as commercial viability and reputation. The benefits of engaging in ADR is that you may be able to reach a compromise or some form of agreement quicker to help minimize the impact on your business. Even though it's important to try to move quickly to get an injunction, this will only be an interim injunction, and you could still be up for a year long or more fight in the courts. The main purpose of the interim injunction is to safeguard the subject matter of dispute, pending the final determination of the matter by a court. When considering litigation, you also need to be confident that any post-employment obligations are reasonable and likely to be enforced by a court. So I touched on what is generally considered reasonable and unreasonable, and courts are really primarily concerned with the question of the balance of public policy and the protection of the interests of the parties concerned as well. So it really depends on those in terms of whether or not it warrants the relevant obligation being upheld. A court will seldom enforce an obligation really that imposes limitations disproportionate to the business interest that is being sought to be protected, and the restraint must also not be too broad in scope, and the interest, or even the information rather, must be legitimate and capable of being identified by you as the employer or company. If ultimately proceedings are to be commenced, you also have to consider the equitable maxim of clean hands, which simply means, the circumstances of your former employee leaving the business may be relevant. For example, any contractual protection you have may be actually invalidated if you, as the employer, first breach the employee's contract. A range of remedies might be sought by you as the employer following a breach of post-termination restrictions and following civil court action. And that may include an injunction that we just mentioned that would prevent the former employee from engaging in any activity that violates the post-contractual obligation. And that injunction could be enforced for a specified period, often at least the length of the restraint clause itself. Damages is also another option to address the harm caused by the breach. So your company may seek damages as compensation, but in these circumstances, the onus really lies on you to substantiate and present evidence of the losses that you've endured as a direct consequence of the employee's breaches. An account of profits is also another option. So in cases where the former employee has benefited from their breach, your company can demand an account of profits that they perhaps made as a result of that breach. And this means that the former employee does not gain an unfair advantage from, of course, their wrongful actions and breach of contract. So in summary, the key takeaways I would say is you should start by getting your employee contracts reviewed and updated by a lawyer to ensure that your business is protected. And your legal advisor should review whether or not the post-employment obligations, such as confidentiality, non-compete, and non-solicitation clauses are enforceable, because these contractual provisions help really to safeguard sensitive information such as intellectual property and perhaps preserve your client relationships as well. They should also consider tailoring the contract to the employer itself, because a one-size-fits-all approach is not always a good strategy. It is important really to consider the unique risks associated with each position in your organization, taking into account things like the seniority of an individual, because it's perhaps more likely that a director will have access to more valuable information compared to a junior employee. You should also ensure that your employees are aware of their obligations. And the way you can do that is conducting regular training and highlighting the importance of protecting the business's confidential information and intellectual property. Excuse me. You should also implement good employment and HR practices, because a disgruntled employee is more likely to disregard their obligations to the company. So what you should really be looking to do is ensure that you identify those employees early and address the issues to avoid them festering into much bigger problems. You should also look to implement strategies to ensure your confidential information and trade secrets are protected. So as we covered before, this could be things like limiting access and maintaining access logs, conducting regular security reviews, and just being vigilant in protecting your business's confidential information and intellectual property. You can also manage your outgoing employees by conducting those exit interviews of employees and developing strategies really to improve the culture. And the exit interviews really can be useful in identifying any sort of high risk employees. So that way you can act quickly before any damage is done to your business. And finally, you should always take swift action, because if you think a former employee is in breach of obligations, you need to get advice quickly and move quickly as well, because as I mentioned before, time is certainly of the essence and a key component that a court would consider. So that really now concludes the main part of our webinar today, and you might find our publication on how to hire and inspire in the UK useful as per the slide shown on the screen. So you can download this by scanning the QR code as well. We also have an upcoming event that may be of interest to you. So our next webinar is on protecting and enforcing your brand, and that'll be next Tuesday, the 26th of November at 11 a.m. GMT. And you can register for this event with the link shown on the screen. Now, we're going to go answer your questions shortly, but while you submit them, I will tell you a little bit about LegalVision's membership. So, LegalVision's membership is essentially a cost-effective alternative to have all of your business as usual legal needs covered. So, that'll be for a fixed monthly fee. You would not only receive cost certainty, but also inclusive benefits, such as unlimited document review, which would include a review of your employment contracts. It would include unlimited consultations, which mean you can book as many meetings with us as you need to discuss your commercial contracts for any of your sort of business as usual legal needs. You can also talk to any of our lawyers on matters such as franchising, corporate law, employment law, so on and so forth. It really depends on your business needs. And your membership with Legal Vision would also offer you unlimited trademark registration or for one very reasonable monthly fee with options to purchase extra credit towards complex matters and ongoing disputes which are charged on an hourly rates basis. And now we'll answer some of your questions. Just going to have a quick look to see if any questions have come through, and then we'll run through those. I think someone may have raised their hand during the session. If you did have a question, please feel free just to submit it in the question box if you've not done so already. I can see a few are just filtering through, so I'll just give maybe another 10 seconds or so, just a few more to pop through. Okay, so yes, I can see a few have come through. Again, while I answer some of these questions, if you have any questions, please feel free to ask away. So one of the first questions that popped through is says, if employees are also shareholders who have similar non-competitive duties to the company by virtue of that relationship, does that change the position for the company significantly? Okay, well, that's an interesting question. So what I would say is that if you have restraint clauses in both the employment agreement and perhaps a separate document, such as a shareholders agreement, then yes, effectively they are both enforceable. And I would say also that courts are really more willing to allow more restrictive clauses, if we call it that, in a shareholders agreement rather than an employment contract. So it is important to also consider perhaps including restraint clauses in the employment contract as well as any shareholder documents as well, such as a shareholders agreement. And as I say, they can be a little more stringent compared to just a regular employment contract. So hopefully that answers the question there. I can see a second question has come through as well by a visitor. So it says, can a non-compete clause constrain former employees who are overseas remote workers? So it's a really good question. So it really boils down to the agreement itself. So the employment agreement, that is, of course, and whether or not it covers both the jurisdictions that you're looking to enforce the restricting covenant on. So we'd look at things like, for instance, where the employer is located, so yourself, where the employee is located, and also the clause itself in the employment agreement. So is it, narrow enough to cover only direct competitors for a reasonable period, or is it quite, broadly drafted, so therefore it could be unreasonable and therefore unenforceable? So it really just comes back to that earlier principle I mentioned of reasonableness, because that's one of the first things that a court would consider if, of course, you have to escalate it to that stage. But just bear in mind, if you do have a situation where you have perhaps employees based abroad, then trying to actually enforce that restraint against them in that foreign jurisdiction may prove difficult, depending on what jurisdiction that is. Just because you have to be aware of things like local laws, and local laws perhaps may not be as strong as the laws that we have in the UK. So hopefully that answers that question there for you. I think we have time for at least one more question. So there's a question here that says, how can an employee define a wall between software products they develop from themselves from the software they develop as a consultant for another company, I guess that says. That's a really interesting question, really. So I would say that it's important to remind employees that generally, really, that in any IP that they really create for yourself during your employment relationship really belongs to you as their employers. And what you should be looking to do is for the employees, you should review their employment contract and your company's policies. And that would ensure that the employee, of course, understands their obligations and also perhaps understands their rights associated with any sort of IP that is created as well. We should also make sure that there is perhaps a clear separation of personal and work environments, so physical and digital separation perhaps as well. Thirdly, I'd probably say it's important to maybe um, separate and stop an employee from using your resources as an employer for a personal project an employee may have, just to really stop any sort of confusion over who may actually who the IP may actually belong to. So to avoid that, it's perhaps better just to tell employees from the outset that they can't use your devices for their own personal matters. You might also want to consider focusing on different industries or domains for personal projects. So, if an employee works for in one industry, but they want to work in other industries, that may be okay because that way there can be a clear separation of the IP and who that belongs to as well. I would say perhaps finally, if an employee is ever unsure, and if you're ever unsure as well, maybe just speak to them, make sure that they seek your written permission because otherwise you might have situations where perhaps they're working for potential competitors as well, which you may want to prevent depending on the situation. So, the key takeaway really there is if your employees want to consult elsewhere and you're happy for them to do that, then they shouldn't really be using your resources and they should be reminded of their employment obligations. So there isn't any sort of issues later on down the line in terms of who the IP may actually belong to. So hopefully that answers your question there. So I think I'll leave it there with the questions. But as I say, if you do have any further questions, then please feel free to book in a call with us using the complimentary consultation offered by this webinar. So that's really all we have time for today. So after the webinar ends, a survey will pop up and we would really appreciate it if you could complete the survey. It only takes around 30 seconds or so. And please, as I say, remember to include your contact details so we can give you that complimentary legal consultation to address any questions that may not have addressed today already. And we can also discuss how to assist you perhaps with your employment contracts and any key clauses to protect your business as well. So thank you very much for joining us. I hope you enjoy the rest of your day.